Hello, I'm Kathy Bryant, Manager of TMLT's Product Development and Consulting Services. I want to welcome you today to the recorded webinar, New Law Impacting Your Practice, Information Blocking. Our presenter today is going to be Sarah Churchill-Llamas. Sarah, the hosts, and the planners of this event have no commercial affiliations or interests to disclose related to this talk. Information blocking is part of a larger law called the 21st Century Cures Act. Today we're going to be focusing on the Office of National Coordinators for Health IT, or ONC, as it's often referred to, Cures Act Final Rule about information blocking. Very simply, it's about access and choice. First, patients should be able to access their electronic medical records at no additional cost. And second, providers should be able to choose the IT tools that allow them to provide the best care for patients without excessive cost or technical barriers. Because this is kind of a new rule, and it is rather complex at times, I think that having some resources in your back pocket is always helpful. So we have provided for you a number of resources. First, from the Office of National Coordinator, we've provided links to their definitions page, their information blocking actors, or who must actually comply with the rule page, as well as information blocking exceptions. Personally, I always find their FAQs, or frequently asked questions, helpful, because I think they've done a good job to continue to add to frequently asked questions as different issues have arisen. This might be a good website for you to actually bookmark and refer back to often, because they do continue to add to this list of frequently asked questions. Currently, the topics covered are general information blocking, who actors are, what electronic health information is, what are interfaces, questions about general exceptions, questions about the preventing harm exception, enforcement, and reporting claims of information blocking. The AMA has two white papers that you may find helpful. The first is, what is information blocking? And the second, how do I comply with information blocking and where do I start? Also, the Texas Medical Association has dedicated a page on their website to the 21st Century Cures Act, Interoperability, Information Blocking, and the ONC's Health IT Certification Program, and that can be found on their website. We understand that this is a new concept, and that there may be questions that you have after the listening and viewing the webinar. And we would invite you to email us at consulting@tmlt. We may not have all the answers, but if we don't, we'll certainly try to connect you with a resource or someone who can actually give you the answer in this evolving situation that we're in. We hope you enjoy Sarah's portion of the webinar, and again, thank you for viewing.
Hi, everyone. My name is Sarah Churchill-Llamas, and I just want to start off by thanking everyone today for joining us. We're going to be discussing the final information blocking rules that came out from HHS and the ONC, the Office of National Coordinator for Health IT. Just to get us started, of course, I'm an attorney, so I have a disclaimer And this disclaimer basically reads as, while I am a lawyer, I am not your lawyer. So a bit about me. Like I said, I'm a shareholder at Winstead PC, and I am the chair of our healthcare and life sciences industry group. I am a healthcare attorney, and I have a special focus on health information technology. In 2014, I was appointed a Health IT Fellow by the Office of National Coordinator for Health IT, and I did that for 3 years until 2017. My practice now focuses on health IT and telemedicine and telehealth, and I am currently the president of the HIMSS Austin chapter, which is the Health Information Management System Society. So I'm very immersed in health IT and health IT issues. So our agenda for this session, it's only 30 minutes, and I'm going to try to keep it as close to 30 minutes as possible. Is first we're going to start off with the background and basics of the data blocking rule. We're going to then start to dive into some of the more nuanced details of the data blocking rule. Then we're going to talk about where we sit right now on enforcement and what to look for, like what could be considered some high-risk actions that you should be looking for in your organization. And then we're going to look at very quickly just what is the other impact on payers and EHR vendors and just others, kind of in the ecosystem, and how are they going to be dealing with the data blocking rule. And then compliance, we're going to really look at what can you do in your organization to make sure that you are compliant with these new rules. So just to start out, what was the intent of the data blocking rule? I think, for years, we had rules under HIPAA that said that the patient needed to be able to have access to their records. And the ONC definitely came down with some pretty harsh penalties for those who did not make copies of medical records, kind of just easy requests. They would just ignore the patient's request. But I think that the data blocking rule really goes deeper because it really drives into interoperability and patient access, but then also just exorbitant costs around interfaces and things like that providers have to bear, and how they have a material impact on the shareability of data. So kind of in a nutshell, this slide really talks about, what was the ONC and the 21st Century Cures Act, what were they trying to accomplish? So like I said, they really want patients to be able to access their records with no additional cost, and providers should be able to choose the IT tools that allow them to provide the best care without excessive costs. And they had to go about this in a way, I think, at first they were trying to really come down on the EHR developers because they really felt like Epic and some of the other systems were kind of hoarding data, kind of being bad actors in the system. And so I think while they at first tried to identify what is data blocking, it just didn't have a lot of teeth, and nobody really changed what they did. And so with the data blocking rule, they've taken a slightly different approach, which is to really put the patient at the center of this. And so now it's going to be more about, if one provider needs records from another unaffiliated provider for the patient's treatment, you can't put barriers in place for that because it's already allowed under HIPAA. So it's going to be kind of things like that where it's really the patient in the center. And I would say it gave them more opportunity to push interoperability when they put the patient in the center, and it helped them better align with HIPAA, and the HIPAA access rights. So, when a patient says, I want my data to go here, you have to send that data to wherever they want, their mother-in-law, the grocery store, wherever they want that to go. And so now what they're doing is they're trying to empower patients through third-party app developers to be able to help patients get access to their records, but also make it easier for providers to share records amongst each other, and not have hospitals decline to give medical records. So I think it'll be really, really interesting, and hopefully something that is really good, and I hope does not bring a lot of additional costs around compliance for organizations. But already, anytime you put a rule in place, everyone is looking at, okay, how can we be compliant? And there's a cost to that, an administrative cost, if nothing else. So, okay, so we're going to start really diving into some of the details. So what is information blocking? So information blocking is a practice that, one, if you're a health IT developer, a health information exchange, or a health network, if they know or should know that practice is likely to interfere with, prevent, or materially discourage the access, exchange, or use of electronic health information, or, and there's a slightly different, there is a variation here. If you're a healthcare provider, it's a practice that if the healthcare provider knows is unreasonable and that it is likely to interfere with, prevent, or materially discourage access, exchange, or use. So the big difference here is that actually health IT developers and exchanges and networks are actually held to a higher standard, because it's not just only with knowledge that they know, but it's also that they should have known ahead of time that was going to create a barrier. Whereas for healthcare providers, it is more about whether they actually knew at the time that was going to be a problem and discourage or prevent use. So some really broad examples of what we're looking at here. So the first is interoperability. So examples are connecting an EHR to an HIE, trying to access records from other providers, trying to migrate from one EHR to another for any number of reasons, even if you just don't like the EHR that you have and you want to upgrade to a different EHR. It has traditionally been very, very difficult to be able to extract the data, map the data, and migrate that data into another system. Access, so patient access to or ability to send medical records, and then affordability, so restrictions on use or exchange, whether that's by contract or other means, and having expensive interface costs. I think this is a really important one. And I hope that will help create a change in how much they're charging for some of these interfaces. So just some background here, the 21st Century Cures Act passed in December of 2016, where they were really trying to promote interoperability and prohibit information blocking by actors. So I referred to this earlier, where they were really trying to make a difference in the way that even some of these EHR programs are sort of architected and how providers are able to use them, and what their licenses look like, and really trying to kind of prevent the data blocking by these actors. But then they realized it just wasn't enough, and they needed to come out with a rule. And so they definitely used a lot of thought, I think, in kind of their approach to this. So March of 2019, they issued the proposed rule, and in May of 2020, the final rule was published. Okay, so who does this rule apply to? So this rule applies to actors. We're all very used to hearing the term covered entity and who's a covered entity under HIPAA. But here we're looking for whether or not someone is an actor. So these are the folks who are considered actors. They're healthcare providers. I put a list of all the various organization types that are considered healthcare providers, from community mental health centers and home health agencies, skilled nursing facilities, federally qualified health centers, ambulatory surgery centers, and then, who is considered a physician under that definition of physician. And it even goes all the way down to chiropractors and podiatrists and dentists. So it's definitely very far reaching. And then health IT developers of certified health IT, and then health information networks and health information exchanges. And health information networks are basically anytime you have two unaffiliated providers who have set up a system so that they can share data. So it's two or more. And then health information exchanges tend to be like more community-wide data repositories or exchanges. Okay, so what information are we even talking about here, right? What information cannot actually be blocked? So this applies to electronic health information, so very, very broad category. From April 5th, 2021, when this goes into effect, until October 6th of 2022, the information that cannot be blocked is limited to what they call USCDI version 1 data elements. And my next slide, I'm going to talk about what that actually is. But I want you to know that after the transition date, the definition of EHI includes all PHI in a designated record set. So this is very, very broad. I would say even the definition under the USCDI version 1 is more broad than we've seen for even some of our basic requirements, like under meaningful use for CCDs and document exchange, because it includes some notes and some free text elements. So EHI does not include psychotherapy notes, just like in HIPAA, information compiled in reasonable anticipation of litigation or administrative actions, or de-identified health information. Okay, so this is the USCDI version 1. So in blue, this is the traditional CCD. This is what, for meaningful use and to be a certified EHR, you had to be able to send a file type that contained all the data elements that are seen in blue here. They have added the data elements in pink. So this is what you're going to have to be able to provide. I think it's interesting that they added the clinical notes section to this. So this is what you're going to have to, be able to send. EHR companies are definitely working hard to make sure that they can do this. And it's until October 6th. So then that means after October 6th of 2022, you're going to need to be able to share the designated record set. So that means, for a physician's office, that is your medical and billing records and any other records used by your physicians to make decisions about patients or about that patient, right, who's making that request. So this is a much broader category. I think as we get closer to this date of October 6, 2022, I mean, there might be some revisions in this, but for now, this is the requirement. So basically, under this rule, you have to share the information unless there is an exception. And so there are 8 exceptions. I'm not going to go into a lot of detail about these exceptions because, one, the ONC has done a good job of putting together a guide for each one of these exceptions and what questions should you be looking at, so that you can make a determination around these exceptions. There are Q&A or FAQs around these exceptions. And so, and I'll tell you, some of these, especially around the procedures for fulfilling requests, it's not real straightforward. And I think your organization is going to come to use probably 2 or 3 exceptions unless, something is going on, like your entire system is down, for maintenance or for an extended period of time, or, there's some other, security issue, or then you might have to start looking at some of these other exceptions. But I think, you're definitely going to see a lot of the preventing harm. It's going to be an exception that gets used, especially if you're treating minors. And then, privacy and even potentially maybe infeasibility. So, the presumption is that there is no exception, and the actors have the burden of proof to actually show that an exception applies. And there has to be a determination made every single time a request is made. And so I think in the long run, because eventually third-party app developers are going to be able to ping systems through what they call APIs, which are basically just like open interfaces. I don't know if you're going to have the opportunity to even use these exceptions in those circumstances. And so I think, I think your own internal policies and procedures are going to need to reflect how you handle these regulatory exceptions if you choose to use them. So, kind of big picture, what does this mean for everybody? So previously, right, if it was permitted by HIPAA, providers and their business associates could share data with another third party. So let's say you had one provider asking for records from another unaffiliated provider for treatment purposes. Obviously that was permitted by HIPAA, but a lot of folks wouldn't provide that data, especially if it had to do with maybe larger quality studies, or if you had a hospital who was trying to gather information about patients. I mean, they obviously shared the patient. The information would be allowed to be shared under HIPAA, but folks would just say no, or I don't feel comfortable. And it's always easier to say no, and it's always safest to say no. But now, if access or exchange of electronic health information is permitted, disclosure will likely be required absent some exception. So that's kind of the major shift that we're seeing. So there is going to be an interplay between HIPAA and state laws to help us understand whether it's a permitted sharing. So if you're looking at HIV status in Texas, obviously we're going to have to look at state law and say, is this something that we can share between providers that may not be affiliated? And I think the answer is going to be no. So we're definitely going to still have to look to HIPAA and state laws to determine whether the sharing is permitted, but then from there decide whether there's an exception that applies to not access or exchange the EHI. Okay, so information blocking enforcement. So right now, the current deadline for compliance is April 5th, 2021. And there are different information blocking enforcement mechanisms that are in place right now. So for health IT developers of CERT or certified health IT, it is the condition and maintenance of certification requirements that are through the ONC. For health IT developers and HIEs and HINs, there are actually going to be civil monetary penalties of up to $1 million imposed by the OIG. These have not been established yet, but likely will be, hopefully by April 5th, 2021, or it definitely gives this less teeth. But we're kind of on the lookout for that. I haven't seen that as of today, March 5th, actually March 4th, really, because I looked yesterday. And then for healthcare providers, it is going to be determined through HHS. So it's a government agency disincentive, and that has not yet been established by HHS either. So more to come on that as well. Healthcare provider enforcement. So in addition to the HHS created disincentives for physicians and providers, HIPAA regulations and penalties still apply. So you can actually get hit with both. The Medicare Quality Payment Program or Medicare Medicaid Promoting Interoperability Program participants, information blocking can affect scores and payment adjustments. The National Plan and Provider Enumeration System, CMS, is going to publicly name providers that don't list or update their digital contact information as required. And then in the 2019 Promoting Interoperability Program requirement, CMS may report providers for information blocking by how they've attested. So it's definitely some different ways that they're trying to get at this. So these are just some general things that I think you need to know for really good context for this rule. So healthcare providers can still be subject to civil monetary penalties if other actor definitions apply. So you could be a healthcare provider, but you could also participate in a health information exchange. You could also or you could even be considered a health information network if you're sharing information between yourself and other unaffiliated providers. I don't know how this is going to really play out if there is an accountable care organization or if you're part, well, yeah, mostly around just accountable care and how folks are pulling data and sharing data and what that means and could that, make providers a health information network. It might, depending on how it's structured. So, and if that's the case, then it would have, your kind of standard would be not just knowingly, making these violations, then it would be knowingly, or you should have known that you're making these violations. So you kind of get pulled into this higher standard if you qualify as another type of actor. Which once again is basically an EHR vendor, a health information network, or a health information exchange. So physicians must release records unless an exception applies. I tried to make that very clear, but I wanted to highlight that again. And following state or federal law applicable to the release of records would likely not be information blocking. So that is a legitimate reason not to share that information. Okay, so now we're going to talk about just high-risk actions. So whenever patients request access to their own records, that it could be a high-risk action if you deny or try to limit the information that they're getting. Providers seeking records for treatment. And I would say any TPO, right? Treatment, payment, or operations under HIPAA. If it's allowable, really you should be looking at this as, maybe I should be sharing this and I want to really take a good look at this instead of saying no. Payers seeking records for value evaluations, so not just audits of a particular service, but actually trying to do sort of these larger scale value or quality evaluations, and then anything having to do with patient safety. So these are kind of the high risk things that you want to be on the lookout for, because I think the ONC would see these violations as being exactly what they're trying to stop. So you definitely don't want to be involved in that. So examples of potential violations, taking longer than needed to provide access to records to an unaffiliated provider or patient. So in this example, this is saying, let's say you could have the records over to another, the patient says, hey, I'd like my records transferred over to this unaffiliated provider, and maybe you could do it the same day, but instead it takes you 5 or 6 or 7 or 10 days to do it. And under HIPAA, you're probably, used to saying, hey, I'm going to try to respond within 30 days. But that could actually be considered data blocking, and that is one of the things that they address in their FAQs is around, providers taking longer than they really need to and sitting on these requests when they have the technology and the capability and they have processes in place to make these determinations and share the records in a timely basis. So there's not any set time. It is more about are you holding things up when you don't really need to? If a provider or an EHR is disabling functionality that would allow staff to easily share data, and you've disabled that, that could be considered information blocking. If you have a policy that requires a patient to complete a written consent before sending records to another provider for treatment purposes, they have specifically stated that that could be seen as information blocking. And this is something that I know a lot of people have in place. They want that HIPAA authorization form because it's kind of a get out of jail free card under HIPAA. But a lot of times that can be difficult for patients to potentially even come in. I know some practices want to have a wet signature on those requests. And so this is a good example of where they would see you asking for that request as being just putting a hurdle in between the patient having access to their records, that you don't need to have that hurdle there. I know of one provider that will require patients to send a copy of their driver's license before they'll share their medical records with them, or even give them access to their patient portal. And I think under this rule that could be considered data blocking. And then of course using HIPAA as an excuse not to share when it is actually permitted by HIPAA. And I think that this is fairly widespread in larger organizations. I think smaller organizations are dealing with patient requests and, maybe requests for, disability or, things like that, but, or attorneys working on disability cases or, but I think larger organizations are making requests to, especially around quality studies and things like that. And so I think that's where you're going to start to potentially get in trouble. I mean, I don't know how much they're going to be enforcing it at the beginning. So some of this is just a little bit of wait and see, especially since they don't really have the penalties defined yet. Let's see here. So I'm looking at the time. All right, so I'm going to keep going. We've got 7 more slides. I want to try to keep us right around 30 minutes. So the CMS rule, the API and exchange requirements for payers. So this is my summary of kind of what the payers are going to be looking at. So by July 1st of 2021, Medicare Advantage and Medicaid and CHIP and all of this, they're required to implement and maintain a standards-based patient access API and provider directory API. And as I said earlier, an API is basically like an open interface that anybody can go out and ping and then automatically get a result back. It doesn't have to have a long setup time or anything like that. By January 1st of 22, organizations must participate in peer-to-peer exchanges upon a member's request. So this is what the payers are looking at. This is what the hospitals are looking at as their potential impact on their certificate of participation for Medicare. So by May 2nd of 21, hospitals are required to send electronic alerts of a patient's admission, discharge, or transfer to another facility or provider. Other compliance dates, these are the certification requirements for EHR vendors that you'll see. So we have a couple of April 5th, same as everybody else, and then December 31st for the 2015 Edition Cures update, and then the API functionality certification is May 1st of 2022. So let's spend the rest of the time just talking about compliance considerations. So first off, you really want to determine, your actor classification, especially understanding whether numerous definitions could apply to you. I think that's a good foundational step. Conduct an EHI inventory and see how it's already being stored and transmitted. Review your technology capabilities and operational mechanisms for providing EHI to providers, to patients, to third-party apps. These are really good questions to be, asking your EHR vendors, and including asking them about application programming interfaces, which are the APIs that will comply with, it's called the HL7 FHIR standard, so FHIR. And then, you really want to start looking at your procedures for release of EHI, including lab test results to a patient portal to ensure compliance. You don't necessarily have to release all lab tests to a patient portal. That's not really what that means. But you can't hold a lab test, have the lab test results, and refuse to give those lab test results to your patient if they're asking for it. And the ONC has even suggested that really the longest you should keep it is to give it to them at the same time that the provider is reviewing it. So I think you could also make an argument that certain more sensitive tests you really want the provider to look at before and maybe even talk to the patient before the patient sees that. And that would be a case-by-case determination, but these are just things to kind of think about. How do you normally handle your lab results? And then obviously, a lot of this is going to come down to your data privacy and security policies. So, everybody already should have HIPAA policies in place. I would say that this rule is going to have a whole lot of overlap with those policies, because there are things that are going to need to happen, especially when someone is requesting access to records, where you're going to say, okay, is this allowed under HIPAA? But then, what do we have to do under the data blocking rule? So you're obviously going to want to review your forms and agreements regarding how electronic health information is treated. So these could be data use and business associate agreements, or even licensing agreements. You want to make sure that you're actually in compliance and not triggering the data blocking rule. So typically a third party's use or disclosure of EHI was normally limited to the purposes of the agreement or underlying services. So you just want to make sure that you can still, and your vendors can still comply with the data blocking rule, even with the existing contracts that you have. You want to make sure your patient release of information requests and authorization forms and waivers, they probably will need to be modified, and make sure that you have a place to document which exceptions potentially you're applying and why, and you want to be able to document that, kind of similar to what you would do under HIPAA, except they're different exceptions, and so you're just trying to document that, and it has to be done every time. And so you want to have good forms and processes so that your staff are doing what they need to do to not just inadvertently run afoul of this rule. So like I said, so that's even developing a process for reviewing and evaluating information requests, and within a time frame. And so some of these exceptions, you actually have to respond within a certain time period, and it's different and under different exceptions. So you really have to have a plan with each exception of what you're going to be looking for, what's your deadline to respond, things like that, and make it as clear as possible for your staff to be able to comply. I think it's a good idea to proactively gather some of your responses and protocols, that you would use or anticipate to use for some of the most common requests for information. A lot of that is going to be the preventing harm exception. That is going to be a big one that people use, the infeasibility exception. I think kind of going through these exceptions, understanding how you would use them under what circumstance, but then just understanding kind of what are some of the protocols around each of those exceptions. And coming up with, some of your past practices to see what your new practices should be for each of the exceptions. So like I said on this last bullet, just sort of caution, responses and protocols, you should have them, and you can have language kind of pre-drafted for folks so that you can make this easy and clean and high quality documentation, but all of the evaluation of the exception and whether it's applicable needs to be done on an individualized basis. So routine and broad applications may not be accepted by the ONC. And I'm right at 30 minutes, I think, right now. So Patient education of risks. So if you are ever concerned about a third-party app that patients want you to send information to, is it interference to warn them of the risks of this third-party app that maybe you know is a bad actor? So, so first and foremost, any information provided by actors have to focus on the current privacy and or security risks posed by the technology or the third-party developer of the technology. That is okay. The information has to be factually accurate, unbiased, objective, and not unfair or deceptive. And it has to be provided in a non-discriminatory manner. But as long as you meet all of those things, it is okay to educate patients on the risks of turning their information over to a third-party app, because I think we're going to see a lot more of this because of these open APIs, where as long as the patient says, hey, I want my records to go to this third-party app, they're going to be able to just go and ping, and they're going to be able to ping your system and the hospital system and the payers and get claims data and the labs and get lab data. So, I mean, I think that it is okay. It's one of the risks that I worry about for patients. I personally think that maybe we should have more consumer protection rules around what these third-party app developers who are not covered by HIPAA, what they can and should do, you know, what restrictions should they have on this data? Can they just go and sell this data similar to what 23andMe does? You know, what should we be doing? And I'll tell you, the best thing that you can tell your patients is to go look at that app's privacy policy in terms of use or terms of service, because under FTC rules, they have to really say, hey, this is how I'm going to use your data, and this is how I'm not going to use your data. And then they have to follow it, or they're going to be in violation. And the FTC has just recently, for the first time, actually cracked down on a healthcare-related direct-to-consumer app for improper sharing of medical data. So I think it's good that they're starting to take a more active role, but I am still personally concerned about consumer or patient privacy. So that wraps it up. I did go a few minutes over, so thank you if you stuck with me. If you have any questions at all, please feel free to reach out to me. I'm sorry I didn't get a chance to answer questions. But like I said, I hope to see you next time, and thank you for attending this session. I hope you have a great rest of your day. Thanks.